And I'm informed that the jury has a verdict. I would simply ask that when the verdict is published by the clerk, that everyone who is here observing the trial maintain their silence according to the dignity of these proceedings. If you don't believe that you'll be able to do that when you hear the verdict, then we should step outside now. Anything to take up before we bring in the jury?
No, Your Honor.
Let's go ahead and bring them in.
All rise as the jurors enter the courtroom, please.
Ms. Scanlon, looks like you were holding some papers. Okay, you can elect as the floor person. All right, you have next. Gail, please. Verdict forms appear to have been completed, the property form. And the clerk can ask for a publisher. Mr. Wilson and counsel, please stand.
In the Circuit Court, 7th Judicial Circuit, in and for Putnam County, Florida. Case number 2020-1021 CF. State of Florida versus Mark Howard Wilson Jr. defendant. Verdict as to be sentenced on count 1. Robert Baker defendant. We the jury find as follows as to defendant Mark Howard Wilson Jr. in this case. A. Aggravating factors as to count 1. We the jury unanimously find the state has proven beyond the following factors beyond a reasonable doubt as to defendant Mark Howard Wilson Jr. in this case. Mark Howard Wilson Jr. was previously contemporaneously convicted of another capital felony, yes. The first degree murder was committed while Mark Howard Wilson Jr. was engaged in the commission of a burglary, yes. The first degree murder was committed in a cold, calculated, and premeditated manner without any pretense or moral or legal justification, yes. B, sufficiency of the aggravating factors as to the first degree murder of Robert Baker. Reviewing the aggravating factor or factors that we unanimously found to be proven beyond a reasonable doubt in Section A, We, the jury, also unanimously find the aggravating factor or factors are sufficient to warrant a possible death, sentence of death, yes. Mitigating circumstances. One or more jurors found that one or more mitigating circumstances was established by the greater weight of the evidence, yes. Eligibility for the death penalty for first-degree murder of Robert Baker. We, the jury, unanimously find that the aggravating factor or factors that were proven beyond a reasonable doubt in section A above outweigh the mitigating circumstance or circumstances established in section C above as the first-degree murder of Robert Baker, yes. Jury verdict as to death. Having unanimously found that at least one aggravating factor or factors has been established beyond a reasonable doubt in section A above, that the aggravating factor or factors are sufficient to warrant a sentence of death in section B above, and that the aggravating factor or factors outweigh the mitigating circumstance or circumstances in section D above, we, the jury, unanimously find the defendant Mark Howard Wilson Jr. should be sentenced to death for the first-degree murder of Robert Baker, yes. Dated this 28th day of October 22nd in Palaca, Putnam County, Florida, Melissa Stalin, foreperson. Verdict as to sentence on count 2, Tatum Baker, descendant. We, the jury, find as follows as to defendant Mark Howard Wilson Jr. in this case. Aggravating factors as to count 1. We, the jury, unanimously find that the state has proven the following aggravating factors beyond a reasonable doubt as to the death of, as to the defendant Mark Howard Wilson Jr. in this case. Mark Howard Wilson Jr. was previously or contemporaneously convicted of another capital felony, yes. The first-degree murder was committed while Mark Howard Wilson Jr. was engaged in the commission of a burglary, yes. The first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification, yes. The first-degree murder was especially heinous, atrocious, or cruel, yes. B, sufficiency of the aggravating factors as to first-degree murder of Tatum Baker. Reviewing the aggravating factor or factors that were unanimously found to be proven beyond a reasonable doubt in section 8, we, the jury, also unanimously find that the aggravating factor or factors are sufficient to warrant a sentence of death, yes. Mitigating circumstances. One or more individual jurors find that one or more mitigating circumstances was established by the greater weight of evidence, yes. Eligibility for death penalty for the first-degree murder of Tatum Baker. We, the jury, unanimously find that the aggravating factor or factors that were proven beyond a reasonable doubt in section A above outweigh the mitigating circumstance or circumstances established in section C above as the first-degree murder of Tatum Baker, yes. Jury verdict as to the death penalty. Having unanimously found that at least one aggravating factor or factors has been established beyond a reasonable doubt in section A above, that the aggravating factor or factors are sufficient to warrant a sentence of death in section B above, and the aggravating factor or factors outweigh the mitigating circumstance or circumstances in section D above, we, the jury, unanimously find the defendant Mark Howard Wilson Jr. should be sentenced to death for the first-degree murder of Tatum Baker, yes. Dated this 28th day of October 2022 in Palaca, Putnam County, Florida, Melissa Stalin, foreperson.
Would either side wish the jury to be polled?
Yes, sir.
Members of the jury, we're going to ask each of you individually about the verdicts that you have just heard. The questions pertain to whether the verdicts as read by the clerk were correctly stated. Madam Clerk, if you would please proceed with polling.
Lydia Canals, juror number 140, agree that each of the findings in this verdict form is yours?
Yes.
Do you, Mary Farrell, juror number 85, agree that each of the findings in this verdict form is yours?
Yes.
Do you, Tanya Cody, juror number 51, agree that each of the findings in the verdict form is yours?
Yes.
Do you, Mary Reeves, juror number 490, agree that each of the findings in the verdict form is yours?
Yes.
Do you, Dana Cruz, juror number 136, agree that each of the findings in the verdict form is yours?
Yes.
Do you, Kathy Decker, juror number 153, agree that each of the findings in the verdict form is yours?
Yes.
Do you, Karen Russell, juror number 512, agree that each of the findings in the verdict form is yours?
Yes.
Do you, Bobby Miller, Juror number 424, agree that each of the findings in this verdict form is yours?
Yes.
Do you, Gail Wright, juror number 249, agree that each of the findings in the verdict form is yours?
Yes.
Do you, Nancy Hughes, juror number 294, agree that each of the findings in the verdict form is yours?
Yes.
Do you, Donald Larimer, juror number 349, agree that each of the findings in the verdict form is yours?
Yes.
Do you, Melissa Stalin, juror number 558, agree that each of the findings in the verdict form is yours?
Yes.
Thank you.
Members of the jury, I wish to thank you for your time and consideration of this case. I wish to also advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied on juries for consideration of difficult cases. We've recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you're also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. At this time, I will go ahead and discharge you as jurors. If your notes are not out here, they'll be picked up in the room and you can leave them there. The two alternates can come forward and join the remaining jury as they go out. Thank you very much.
All rise, this jurors exit the courtroom, please.
Thank you. Please be seated. I have a 3-hour time block set aside on my calendar on December 1st, starting at 10 o'clock for a Spencer hearing. Both parties available at that time.
State would be available.
Just checking.
It's immediately before the HIU pretrial that day, so some of you will be here anyway.
It's fine with the state. I don't know how much.
I'm just checking.
It's generally their timetable, but whether any additional audits.
While we're waiting for this Peoples to do that, I will go ahead and I erroneously ordered it before, but now I'll order a pre-sentence investigation by the Department of Corrections to be completed. This gives us 30 days to get that done.
Defense is available that morning.
All right, so December 1st at 10 a.m. We'll commence with the Spencer hearing. Anything else we need to take up today?
No.
All right, defendants remanded to custody of the sheriff and sentencing. And we will be adjourned.
Next, and so 1 a.m.